All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save the United States and this honorable court. This honorable court is now in session. Please come to order.
Thank you. Good morning, everyone. Welcome to this remote session of the District of Columbia Court of Appeals. I apologize to counsel who are here with us and to everyone who has been waiting for the delay. We had some technical issues. I hope they won't be repeated. Let me say no more and immediately go to our first case, which is number 19 CV 0725 DC Chamber of Commerce versus London and Mead et al. Counsel, when you're ready, please.
May I please the court? I am Ryan Jones, counsel for the DC Chamber of Commerce, the appellant. Good morning, Judges Fisher, Thomas, Thompson, and McLeese. I would like to reserve 4 to 5 minutes for rebuttal.
All right.
This is a contract interpretation matter which should be reviewed de novo according to Alderman versus Ackerman, as well as the Tillery case. The chamber, as I will refer to the appellant here, will present that the chamber was not obligated or bound to pay for the appellee's fees. And the plain language of the contract is unambiguous, the contract or the engagement letter is unambiguous. It does not obligate the chamber, nor does the extrinsic evidence, if found to be ambiguous, to bind the chamber. Thus, the matter should
Counsel,
be
with respect to the plain language of the engagement letter, there's a sentence at the end that says, in addition to legal fees, comma, you, a somewhat ambiguous pronoun, I guess, through the sources we discussed, will be responsible for all out-of-pocket expenses.
That's right. So,
I'm interested in your view about lack of ambiguity, focusing on the words "in addition to legal fees, you will be responsible." Do you think do you think you is clearly Mr. Winko? Do you think that there's really no responsibility at all? How do you parse that sentence?
Yes, of course. So we look to the request for admissions and the responses thereto. Mr. Mark London he's the Mark London of the London and Mead. He responded to that request as, what does the you mean? And he said, it speaks for itself. That was their response, meaning the language speaks for itself. And if you look to Harry Winko's deposition, as well as Mark London's deposition, they describe that Harry Winko, he admitted that he signed as an individual. Mark London, in his deposition, said Harry Winko was the client. And if you think about
make sure you may be working around to this, but are you saying you think the word "you" in that sentence is unambiguously refers to Harry Winko as an individual?
Yes, Your Honor.
And so it's your position that Harry Winko actually is personally responsible for the fees?
So during the deposition, and I think it's been made very clear with—
Well, leave aside for a minute the deposition. I'm just asking about you were saying the contract is kind of unambiguous on its face.
It is.
So just on its face, do you think this contract makes Mr. Winko personally responsible for the fees as an individual?
He is not personally responsible for the legal fees.
Well, if he's not the you on the plain language of this, who's responsible for the fees, then who is?
Mark London and Harry Winko came to an understanding that they would have a group that would pay for the legal fees. This group was going to work together and raise money to cover costs. And Harry Winko, using his extensive network, be able to generate enough revenue to cover the fees for this contract.
In Mr. London's deposition and in his affidavit, as I read them, he seems to say that Mr. Winko made a commitment that the chamber would see to it that the lawyers' fees were paid. Do you disagree with that summary of what he said? Do you think I'm misreading what he said?
I don't think you're misreading what he said, but I definitely disagree. And I believe that when you look to extrinsic evidence, and these are email communications between the parties during and after the litigation, it clearly shows that Mr. Winko was operating as an individual and that there was no other oral agreement behind the scenes to obligate the chamber. This was Harry Winko.
Well, if you agree with my summary, Mr. London seemed to be describing an oral agreement behind the scenes, one that preceded the work that the lawyers did.
Right.
Would you agree with that? He seemed to be describing an oral agreement?
And if we look to their complaint, they never alleged.
Answer my question. Would you agree that Mr. London seemed to be describing an oral agreement?
Yes, and that's reflected in their summary judgment motion that they sought an oral agreement. They sought to prove that there was an oral agreement, which was actually barred by the statute of limitations by the time they raised that as a concept for how this the parties engaged.
The oral, what was barred by the statute of limitations?
When the appellees filed their motion for summary judgment,
Yes.
That was the very first time that they alleged an oral agreement. And by that time, the statute of limitations had run. When they filed, they never mentioned it in their complaint. Their complaint was never amended. And by the time they mentioned an oral agreement in their summary judgment motion, it was barred by the statute of limitations.
You're suggesting that the statute of limitations barred an effort to enforce an oral agreement, to enforce that oral agreement?
That's correct, Your Honor.
I don't see, was that argument in your brief?
It was.
I don't remember seeing it. Where is it?
I'll have to double back to the appendix, but it is in our reply brief to their motion for summary judgment.
Oh, not in your brief to this court, in your reply to their motion for summary judgment. Is that what you're saying?
Yes, it was there. And I don't believe that they argued for an oral argument, an oral agreement in their brief.
And you think that even though their complaint for breach of contract was timely, that their reliance on breach of an oral agreement was untimely?
That's correct.
Is that what you're saying?
Yes, and I believe the court below also found that. Judge Williams said during the pretrial hearing, the pretrial conference, well, there's no oral agreement. And I think that has been conceded by the appellees if you look to their brief, as they agree with the findings of the lower court in whole.
Well, let me put that aside for a moment and ask you this. If there was an oral agreement between Mr. London and Mr. Winko that the chamber would ensure that the lawyers were paid, what is the contrary evidence that the chamber presented in its opposition to the motion for summary judgment?
So there are a few things that are there. First are statements that were made directly between Mark London and employees of the DC Chamber of Commerce. One such being Erica Wallington, who asked who was ultimately responsible for the legal fees, to which Mark London replied, "I anticipate that the group who has funded the litigation to this point will continue to fund it." And at that point, when the question was asked, the DC Chamber never contributed to the funding of the litigation. As time went on, in January of 2016, Mark London reached out to Erica Wadlington and asked or prompted her to alert the group that their retainers running low. Could more funds be raised? And then in May of 2016, the issue came up again, and Erica Wadlington asked Mark London, "How do you intend? Who is responsible for the legal fees?" And Mark London replied, "It's for the committee to pay." And that committee is a group that was known to Mark London that would be, for lack of a better, or the term that was used, pass the hat around the business community to hope that fees would be contributed for this effort. And
Well, that committee wasn't known at the time this contract began or the contract was made because it wasn't even in existence, correct?
That's correct. But to that point, on I believe August 19th, there was a conversation between Harry Winko and Mark London. It's embodied in an email where they have an exchange that says, "You need to unwrinkle a wrinkle. How do I unwrinkle a wrinkle?" And you can see that at the appendix, page 701. It's an email.
And what's your point about that?
That's when the parties knew that the DC Chamber of Commerce could not participate in this by contributing money or running any sort of the operations for this litigation. They had to remove themselves. And they could not be a part of it. And that was disclosed to Mark London.
Does
Mr.
any of
Jones?
that, go ahead, Judge Fisher.
Thank you. Mr. Jones, I'm confused.
Yes, Your Honor.
I thought you started out by saying that it is unambiguous upon reading the engagement letter that the chamber is not responsible for paying the attorney fees. Is that correct?
That's correct, Your Honor, yes.
Then why are we talking about so much extrinsic evidence?
These are the questions that were prompted and I'm answering them, but I do believe if you read the face of on the contract's face, it's unambiguous and it's speaking to Harry Winko, the individual. It does not get the chamber get Harry Winko in his professional capacity. And that was found by Judge Epstein originally when the motion to dismiss was granted.
Is it clear from the engagement letter who is responsible for paying the fees?
The lawyers drafted their engagement letter.
Is it clear from the letter who is responsible for paying the fees?
The language used was, "We anticipate that the legal fees will be covered by various members of the DC Chamber of Commerce." That is the understanding that the parties had, that there was going to be a fundraising effort through this business community, and that was understood.
Well, that's part of the language used.
That is.
Another part of the language used at the end was, in addition to legal fees, you, through the sources we discussed, will be responsible.
Right.
Which implies that somebody is responsible for fees. And that somebody is somebody who's being addressed as you in this letter. But you're saying that the you isn't Mr. Winko, because earlier in the letter, at least in his private capacity, because the letter earlier says you personally will not be responsible for fees and expenses. So the letter seems, if it's only referring to Mr. Winko in his engagement letter, if it's only referring to Mr. Winko in his personal capacity, the letter seems contradictory. It's got a part that says you won't be, and then another part that says, in addition to legal fees, you will be through sources. So it seems like the letter either is intrinsically, internally inconsistent, or it's ambiguous because there is some other you who is being referred to as responsible through sources. And maybe that's Mr. Winko in his capacity as CEO of the chamber, or maybe it's the chamber's legal entity, or who knows. But it seems to me that in answering whether the language is ambiguous, we can't focus exclusively on the language that you have been primarily focused on, and need to focus also on its interaction with this other sentence. Do you agree that we read them both together.
Your Honor, respectfully, if you look to Harry Wingo's statement regarding, well, let's just look to.
Again, I'm focused for a minute just on whether your lead assertion, which is that the engagement letter unambiguously relieves the chamber of any responsibility for fees. And the question is, I'm having a hard time figuring out what it does do unambiguously, because either it's using a pronoun you without that's not referring to Mr. Wingo in his personal capacity, or it's saying two opposite things about Mr. Wingo in his personal capacity. And either way, I end up being uncertain what the engagement letter contemplates.
The contract drafting theory of pro-contra referendum requires that any ambiguity be skewed against the drafters. Mark London was the drafter. The ambiguity should be skewed against him. And that is the position of the chamber. If there is any ambiguity, which we believe there's not, especially when we know that you is only referring to the person that the letter is addressed to, and that's Harry Wingo.
Well, then, so tell me just, so do you agree with this? If that's what you only refers to, then the engagement letter both says he is responsible and says he is not responsible for fees and expenses. Says both those.
Right. The responsibility is for Mr. Wingo to use his wealth of his wealthy network to collect fees, collect funding to discharge the fees. That was the understanding between the two parties. That is why it's addressed to Harry Wingo. Harry Wingo, and it's clear because if you look to what Harry Wingo did in his conduct after he was separated from the chamber in December 2015, he continued to reach out and ask individuals for money. In March of 2016, if you look at appendix page 366, Harry Wingo comes to the DC chamber and asks the DC chamber for a contribution of $10,000. That was in his personal capacity. And that was him asking the chamber for a contribution. So it was known that the chamber was not going to be responsible for the legal fees in total or in part.
Did anyone breach this contract?
That's an interesting question, which I would like to start by saying the attorneys continued to perform work through the end of litigation to which there was a settlement. There was a time during this process in March where the language was asked for them to pause. And then in May, Harry Wingo wanted to step down. And another plaintiff was proposed to replace Harry Wingo. His name was
I think we're getting pretty far afield from my question.
Okay.
A few minutes ago, you had said, according to this engagement letter, Harry Wingo was obligated to use his networking skills to get various people to pay the fees. So did Harry Wingo breach this agreement?
What happened, Your Honor, was in May of 2016, Harry Wingo asked to step down.
Yes or no? Did Harry Wingo breach this agreement?
The chamber's position is that the chamber did not have any responsibility and they did not breach. And I don't think the idea has ever been put out there that Harry Wingo was the person who breached. I do believe that there was an accord and satisfaction made to have Harry Wingo replaced as nominal plaintiff. So when he decided to step out, that was okay with Mark London and the league. So there was not necessarily a breach, but an understanding that he could step away and his responsibilities were dissolved.
Let me ask you this question, Mr. Jones. The record discloses that the lawyers were obligated to join the Chamber of Commerce. What was that about? What significance does that have in trying to sort out what happened here?
I think when you look to the way the business community operates, when I use the word business community, I think we're talking about all the businesses in Washington, D.C.
Yes, what significance does that have for the issues before us, if any?
(501c6). It thrives off. Hello.
Mr. Jones, I think your sound went out. I did not hear you speaking to me.
Okay, can you
I
hear me
can
now?
hear you now, yes.
Okay, so referring to the DC Chamber of Commerce, having the London and Mead law firm join the Chamber of Commerce as a member, I think that's just the normal state of practice for doing business. It's a interconnectedness that engenders a good feeling and good faith just operating with one another. So if we're going to, be helpful to one another, they think it would be a good idea if this law firm was a part of the membership of the DC Chamber of Commerce. I think that was just a good faith measure.
Does it have any bearing on whether the chamber was the client? Any bearing on resolution of that issue?
No, Your Honor. The chamber has thousands of members which pay dues, and that's how it's able to survive through membership fees.
I know you wanted to reserve time for rebuttal. We've not managed to do that, but we'll give you a couple of minutes if you need them. Let's go to your opponent. Thank you.
Thank you.
Good morning. May it please the court. I'm Craig Riley for the appellees, the lawyers, including myself pro se. We submit the court should affirm the summary judgment entered below. Upon consideration of a full record on cross motions for summary judgment, with all the evidence the chamber wanted to present, the Superior Court, Judge Yvonne Williams, found that the record evidence established these four things. One, that Harry Winko, then the president of the DC Chamber of Commerce, quote, was acting on behalf of the chamber, close quote, when he executed the engagement agreement with the lawyers, which had been approved by the executive committee of the chamber's board of directors, which wielded the chamber's full authority. Second, that there is no material fact that supports the chamber's contention to the contrary. And third, that is approved by the executive committee, the chamber would raise the money to pay the lawyers, but failed to do so, and that no reasonable trier of fact would find otherwise. So she granted the lawyers.
The third things.
By the way, Mr. Riley, Mr. Jones said that your position is that there was no oral agreement. Is that correct?
No, Your Honor. When we sought summary judgment, we argued in the alternative that there was either an oral agreement that preceded the engagement letter, or that the engagement letter memorialized the oral agreement, and that either way extrinsic evidence would be used to interpret the engagement letter. And
did the trial court find that there was an oral agreement, or did the trial court instead interpret the engagement letter?
The trial court interpreted the engagement letter, but I think it's two paths to the same point. And Judge McLeese, to answer your question, who is you in that final sentence? That was confronted by Judge Epstein, our original Superior Court judge, at the outset of the case when he reinstituted it. And he determined that the you, and this is Judge Williams adopted this ruling later in the case when she granted summary judgment, you referred to Harry Winko as the nominal plaintiff, which implied that someone else would control and fund the litigation. Judge Epstein, in fact, found that this was an agreement under which the client per se would be Mr. Winko, because a registered voter has to be the plaintiff in this litigation, but that he, as the nominal plaintiff, was a stand-in for the Chamber of Commerce.
Can I ask you, it seems to me there's a potential difference between, I think, what might have been either the third or the fourth thing you listed the trial court as having found and your position. So assume for a moment that the only reasonable way of construing the engagement letter in light of the extrinsic evidence is that the chamber as an entity had agreed to try to raise funds to finance the fees. that's a different agreement than like a guarantee. You know, I personally will pay the fees if I can't raise the funds. Aren't those potentially distinct legal promises?
Not really, Your Honor, given the context here of the engagement letter itself. The agreement was that they would pay the fees, and yet there was an estimate of fees of $100,000.
I'm sorry, what, now what, I mean, that's your assertion, I guess, and that's what's in dispute. But if you're focusing now for a minute on the language of the engagement letter, where are you pointing to for the idea that there was an agreement to pay the fees?
This would be the language in the end of the first paragraph. It says, we agreed a reasonable cap for the fees in the process through appeal would be $100,000, but that is an estimate only and could be more or less depending on the course of litigation. We agreed also that while you will be the nominal plaintiff in the litigation, you personally will not be responsible for the fees and expenses. We anticipate that all fees and expenses will be paid by various members of the DC Chamber. And when that was,
we anticipate that fees will be paid by an entity other than the signing entity or the person for whom the signing entity works is a funny way, ambiguous at best way, as a promise by the the chamber as an entity. I mean, this is a document that is. It just seems to me that it's pretty ambiguous to say we anticipate that fees will be paid by other people. That's a funny way to promise I will make sure the fees are paid.
I think in the context, though, Your Honor, particularly with the extrinsic evidence, which I would like to recite to the court what it was, because in context, this statement makes perfect sense that the DC Chamber was the one promising to raise the money from its own various members. Again, this is not saying that it would be paid by various members of the business community. It would be paid by various members of the DC Chamber of Commerce, which was what we were told. Just a brief chronology would help, I think, here. That when this initiative first came up, the DC Chamber organized the business community to oppose it. And Mr. Winko, in fact, gave testimony with the knowledge of the executive committee of the board at the Board of Elections hearing to stop the initiative from even being accepted. At that time, DC Chamber's Director of Government Relations, Erica Wadlington, organized a subcommittee of chamber members to lead the legal challenge. This is found at page 211 of the appendix. At pages 208 to 209 of the appendix, Ms. Wadlington added Andrew Klein to this committee to make sure that all the work would be done by the chamber to lead this fight. When the Board of Elections accepted the initiative on July 21st, the very next thing that happened was on July 23rd, 2015, Mr. Winko met with the executive committee of the chamber. And this is what their minutes of that meeting reflect. I'm quoting, President Winko asked the committee for approval for moving forward with the chamber taking the lead in challenging the DC Board of Elections decision to allow a minimum wage ballot initiative and Harry Winko filing a complaint in DC Superior Court in his personal capacity as a registered voter in DC. The motion was approved by a voice vote. The committee discussed the next steps of raising a legal fund of approximately $75,000 to $100,000 and finding a law firm to represent the chamber in this matter.
Well, now you've got me a little confused. Is it your view that you were representing the chamber, or were you representing Mr. Winko?
We were representing Mr. Winko as a voter, but in the same way that an insurance company pays for a.
Well, no, I understand. I was just focusing on the word represent because the agreement, the executive committee minutes seem to contemplate a different arrangement at that point. Although earlier on they contemplate that Mr. Winko will be, suing in a personal capacity. Right. So it seems to generate some more confusion about who's representing whom. And can I ask you, where in there do you find anything about the committee, approved, agreeing that the committee would be legally responsible for the fee?
implicit in the idea of raising the money and organizing the subcommittee within the chamber members who would be leading this fight and who participated throughout the litigation, monitoring all the work that we did. And all of the work we did was cleared by, approved by, and edited by Erica Wadlington, the DC Chamber of Commerce Government Relations Director. That's who we were working with and for in this matter. They constantly.
I definitely have all that, and some of those points might be, might have been very, very good basis for some kind of action in quantum area or the like, which I don't understand to ever have been brought. But just in terms of, I'm not sure it's implicit. If I am a legal entity and I say, here's my plan. I'm going to try to raise some funds for other people to pay you some money. If I promise to do that, or I plan to do that, there's another significant step between undertaking to raise funds from other people to give money to somebody and agreeing to be personally responsible as an entity for it. Those seem to me different, and I don't see that the one is unambiguously implicit in the other. It's potentially implicit, sure.
Your Honor, I don't think there is a mechanism by which to enforce the promise to fundraise to pay the legal fees in this instance, other than to have the backstop to that be the entity who's doing the fundraising be ultimately responsible, which is what Judge Williams.
No, and that might be a very good argument for why you should draft your engagement letter to be explicit about who's legally responsible.
It could be a way of having written this in a different manner, but we believed under the circumstances here, and I submit to the court when the extrinsic evidence is considered fairly, shows that the DC Chamber was the one behind all this. And this
and here's my question. And you agree that on this point, at least, the issue is whether, taking as a given for a minute that the engagement letter is ambiguous about whether the chamber is legally responsible for the fees. And then the issue is, okay, what's the extrinsic evidence one way or another? Could a reasonable fact finder find for the chamber or against the chamber, if that's the inquiry? There is, I guess, testimony from Mr. Winko describing his understandings and his conversations with Mr. London, which was it was a pass the hat operation in among the members of the chamber, but also other people, not even non-members of the chamber. What Mr. Winko says in his deposition, I'm paraphrasing. Tell me if you think I'm paraphrasing unfairly. And so it seems to me, at least arguably, that reasonable fact finders might agree with you. Look, the only way of reading this sequence of events in the agreement is that the lawyers, can't be understood to have agreed to do all this work and have no promise of payment from any entity that was enforceable. I get that line of thought for sure. But your opponent's argument is, if you consider the extrinsic evidence, you can look at it differently, which is the lawyers agreed, both, in terms of maybe the more natural reading of the engagement letter, but also the extrinsic evidence. What they agreed to was they were going to have a nominal plaintiff. He's not responsible for the fees. There's a plan about how to finance it. The plan is the chamber is going to go hand in hand to non-chamber, to people who are legal entities other than the chamber, and the lawyers kind of bore the risk of, if that didn't pan out, then the lawyers bore the risk of it, and maybe they could sue in quantum meruit. Maybe they could sue if the chamber didn't do well enough at trying to fundraise. Maybe they could sue for breach of the covenant of good faith and fair dealing. Why couldn't a reasonable fact finder be unsure about which of those two is right and have the judgment depend on how the fact finder assess the evidence and the credibility of witnesses and the like?
I think, though, Your Honor, that while you framed the issue, I think correctly, the extrinsic evidence that the parties presented all favored the construction that Judge Williams ultimately adopted below, which the lawyers had argued for. For example, in Mr. London's declaration, which was unrebutted, there was no rebuttal declaration submitted. He said that Mr. Winko told me that the DC Chamber had agreed to authorize and pay for a legal challenge to the minimum wage initiative, and that he personally would be the nominal plaintiff, provided he bore no financial responsibility for the lawsuit, which is exactly what the executive committee had done that very morning of July 23rd, 2015, before Mr. Winko met with Mr. London. The letter identifies him as the nominal plaintiff, says that all fees and expenses would be paid by the various members of the Chamber of Commerce, which is his way of saying to us that we're doing, that we, the Mr. Wingo, we, the chamber, are doing the fundraising.
Yeah, can I ask you, so you say it's unrebutted, and I'm just curious how you address a particular piece of evidence. So this is in the appendix at page 284. It's the deposition of Mr. Wingo. And he's asked, do you remember discussing any sources of payment with Mr. London at all? And he says, the only thing I remember is I wouldn't be personally reliable and that there would be a pass the hat effort to raise funds through members of the business community. Why isn't that, if credited, why isn't that inconsistent with a view that Mr. Wingo, in fact, agreed as the CEO of the chamber for the CEO to be held responsible as a legal entity for the fees, either as a separate oral agreement or, as some of the extrinsic evidence that would bear on the interpretation of an ambiguous engagement letter?
That would be a pretty slender read given the other statements made by both Mr. Wingo and Ms. Wadlington as we were preparing to file this lawsuit on their behalf. For example, when they sent out the fundraising letter to their own members, and they also, without talking to us about it, they also did contact, apparently, outside business groups. They said that this is on their own letterhead by their own director of government relations. Thus, we, the chamber, have amassed the expertise of our government affairs committee and sought advice from well-recognized litigators, all in an effort to engage legal counsel and to establish and administer a legal defense fund. The minimum wage legal defense fund will be used to support the cost of litigation, lawyers' fees, legal advice, and the filing of the court challenge to address the proposed initiative and prevent the measure from advancing on the 2016 ballot.
Can I ask you, I got that as evidence supporting your side of the case for sure. In his argument today, your opponent cited a couple pieces of evidence from your witnesses or your side of the case that he argued cut against your position, including statements about it's the committee that will be responsible. So what do you make of the evidence that your opponent is also trying to rely on along those lines?
It's for the committee to pay email was an inquiry very late in the case. This is like in March or April of 2016 as the litigation was winding up. Ms. Wadlington receives from Mr. London an email attaching our invoices, which were addressed to the DC Chamber. Harry and Erica, I'm attaching the most current invoice for payment. Thanks. Erica Wadlington, on her DC Chamber email, writes back, thanks, I'm trying to access the PDF but want to ask a question. Is this, the invoice, intended for the DC Chamber? I thought Harry was the client. And Mr. London says it's for the committee to pay. And for us, we were told the committee was simply the conduit through which the DC Chamber was raising the funds and making the payments. We were told it was connected to the DC Chamber, that is under election law in DC, established, administered, and financially supported by the connected entity, in this instance being the DC Chamber. It was simply a conduit through which we were being paid. So his statement that is for the chamber, is for the committee to pay, was simply saying, this is the bank account from which it comes, which is controlled by the DC Chamber.
There were a lot of questions in the record about who actually cut the checks to pay the lawyers, and no one seemed to know. But are you saying that the checks came from a bank account of that Committee for Fair Employment Law? Is that what happened?
Yes, apparently
I'm
that
not
is.
sure there's record evidence of that, because the question was asked several times and the answer was, I don't know, I don't remember who wrote the checks.
I think at one point during the the hearing before Judge Williams, she asked me from whom I received my checks, and I was paid from Mr. London's account. So Mr.
Right.
London submitted the payment. So I did not know firsthand, but I do know now, looking back at the record, the checks to London and Mead apparently were all paid from the committee account, which we had been told was the conduit for raising the fees and making the payments.
The minutes from which you were reading, you stopped before the end of the sentence in which the minutes say something about filing an amicus brief. What significance does that have for the issues before us, if any? The contemplation that there would be an amicus brief filed, apparently on behalf of the chamber.
I don't think it has no witness testified as to what that might have meant or was followed up. It simply may have been a misuse of a term of art because it was clear here that the only way to challenge the initiative was for a registered voter, and Mr. Winko was stepping up to be that registered voter. The registered voter has to file that initiative challenge. And in this case,
Go ahead.
In this case, what the parties that were participating in the initiative litigation were Mr. Winko as the challenger, and the Board of Elections is the formal defendant. The proposer, who proposed the initiative in the first instance, was allowed to intervene, and then the Office of the Attorney General, after the initial rulings by Judge Maurice Ross, finding that the Board of Elections was not properly constituted and ruling in favor of the chamber and Mr. Winko, then the Office of the Attorney General intervened and asked for reconsideration of those rulings, starting another 3 months of litigation with now 3 opponents, the OAG, the proposer, and the Board of Elections. But the DC Chamber never intervened, and its spokesman was Mr. Winko. And we took our direction. Now, we also submitted to the record all the email comments we got to all the papers we submitted in this litigation were sent first to Ms. Wadlington, who commented on them extensively and sent back edits and directed all of our work, and congratulated us when we won and talked with us about what to do next at each step of the way. So she was the Director of Government Relations at the DC Chamber of Commerce, reinforcing, I think, the more overwhelming evidence that the client here really, who was responsible to pay, was really the DC Chamber of Commerce, who initiated this, directed the work, took credit for it when it won. They made the announcement that they had won. They understood it. The only time they didn't understand this contract was after they got into a dispute with Mr. Winko and he was forced out. And it was only then that they started making excuses that they weren't the ones responsible to pay this and that they wanted other entities to step up. This is stuff we never saw in real time. We saw it only in discovery, that the DC Chamber had these internal disputes with Mr. Winko about the paying the fees, and that the new DC leader, Ms. Singletary, said, well, we want other entities to pay this. We're not going to pay anymore. And that's when Mr. Winko said, well, you ought to at least pay this $10,000. And she said no. So that all happened 6-8 months after the July meeting with Mr. Winko when we were retained, and occurred as the case was getting ready to be up on appeal.
Can I ask you just to clarify?
Go ahead, Judge.
I just had one clarifying question, which is, maybe you misspoke earlier, but I want to make sure I understand your position. I know that in your view, Mr. Winko was a nominal client. He's a client, though, for sure. You agree he was a client of yours?
Yes.
And do you think the chamber?
Right.
Do you think the chamber was a client of yours?
I think in the same sense that if you have an insurance company paying for the litigation of its insured who was in a car accident, you have certain ethical duties to the client, the insured, to represent him fully in court, but knowing the whole while that the insurance company is the one who's paying the fees. That doesn't compromise your...
I'm not sure, because I am not as familiar. I mean, you're drawing an analogy to an area of law that it just poses further questions about insurance law that I don't have to hand. So it'd be easier if you would tell me, do you think that the chamber was your client?
In the sense, they were not the party to the litigation, but they were the
Well, I know you think they were paying the fees, but I'm just asking, do you think they were your client?
No, I understand, Your Honor. And when we look, when you look at, we've analyzed this before the district court, the Superior Court, under Rule 1.5, and we had this with Judge Epstein way back at the beginning of the case. He says that, and under Rule 1.5, you can have a client, Mr. Winko, but you also can have an agreement with another party that they will be responsible to pay the fees, provided.
I understand that. I definitely understand that. I just wanted to make sure I got a clear answer as we analyze this, whether your position is that the chamber was your client, or whether instead your client was your only client was Mr. Winko in his individual capacity, and that you had a contractual arrangement where there would be fees paid by some entity who was not your client. And you're shaking your head. I'm not sure I'm getting a clear answer, because it sounds like you don't want to say.
Sorry, I'm an active listener, Your Honor. I'm.
Oh, I don't mind. No offense taken.
Yeah. We owed responsibilities to both Mr. Winko as the client, and we considered the chamber to be the party that retained us to represent Mr. Winko. We owed duties to them. I would say in sort of a non-legalistic sense, both of them were our clients. But
well, my question is a legal. My question is a legal one, not a non-legal one. And
okay.
It sounds like you're a little unwilling to just answer.
No, I would say that
were they your legal client or not?
Yeah, I think that the chamber was our client for these purposes, who had appointed their nominal plaintiff, Mr. Winko, to be the plaintiff in the case, who we would be representing directly in the litigation. So we had litigation, a client for the litigation, Mr. Winko, and we had a client for the engagement, which was the DC chamber.
Before you end your presentation, I want to ask you this. Mr. Jones says that to the extent that you're relying on an oral commitment by Mr. Winko on behalf of the chamber to make sure the lawyers were paid, you have a statute of limitations problem. What's your response to that?
I don't think we do, and I don't think it was raised below or here. Certainly, no parties have briefed it. We had argued for breach of contract was our complaint, and it was not. That was the claim was breach of contract, and we didn't specify oral or written.
Well, actually, I thought the complaint says breach of the engagement letter. Which,
again, the engagement letter serves two purposes here. One is the ethical responsibility under Rule 1.5 to have an express statement of the engagement, but it could be either confirmatory of an oral agreement, or it could be a standalone written agreement. And below, we argued that both applied, and that the breach of either the oral agreement or the engagement agreement would lead to judgment in favor of the lawyers.
All right, thank you, Mr. Riley. Mr. Jones, we'll give you 2 minutes.
Yes, quickly looking to Grice versus Levine. Once the court determined that the contract was ambiguous, summary judgment is precluded. However, the judge abused her discretion and tried to resolve the ambiguity herself, and then reviewed the facts in the light most favorable to the moving party, which was the plaintiffs, and that was also runs afoul of the standard in the Nader case. The lower court needed to stand in the position of a reasonable juror acting reasonably and determine that there is no way that you could find for the non-moving party. And she did not review the facts in our favor. And she also said that she was uncertain of what a reasonable juror would do. She didn't meet the standard anywhere. So then we raised a point about the meeting minutes, that the court should have allowed parole evidence to be provided to clear up any uncertainty in the meeting minutes. And as he pointed out, there is uncertainty. Was the chamber going to file an amicus brief? Did that ever happen? No. So the chamber did not get its full opportunity to litigate the case and have a reasonable juror determine any of the ambiguity here. Lastly, we have the concept that you can't guarantee for raising funds. That would be a new nuanced legal standard that if you're going to raise funds, you have to guarantee that you can raise the funds or somehow be obligated. That is not the case here. Also, we have just a balancing harm. If you're looking at the blind scales of justice, you're saying, is it okay for a client to overbill after being told, look, it's going to be $100,000. We're now asking for $145,000.
What do you make about the language, though, in the engagement letter that says it could be more? That seems like your weakest argument.
Okay, sorry, I would draw it, but it is $45,000 more than the ballpark figure that they put out there. But moving forward, you have Mr. Riley, who is arguing zealously and has to be a witness to whether or not that was his client or not. And he's making argument and testimony at the same time, which the rules of professional responsibility preclude. And you also have to look to the concept that as a practitioner, you write an engagement letter. Who's your client? Who's to pay? How should we be setting the standard that it's okay to write an engagement letter like this and then have somebody who constantly asked who's responsible and being told that there's this other committee and then being sued on the ambiguity of the letter that they wrote?
I think we'll leave it there. Thank you, Mr. Jones. Thanks to you, Mr. Riley. The case is submitted.
Thank you, Your Honor.
Our next matter is number 17 CF 1180 Acer Lee versus United States. Good morning, counsel.
Good morning.
Good morning.
Judges.
I think we're ready to start, Mr. Whitehead.
Okay, great. Good morning. May it please the court, James Whitehead on behalf of Appellant Acer Lee. I'd like to reserve 2 minutes for rebuttal. And because the government agrees that suppression is warranted if this court finds that the police's discovery of items of evidence in Mr. Lee's backyard violated the Fourth Amendment, I will begin and focus my time with that central issue. The trial court erred in its backyard emergency aid ruling for 2 reasons: entry and scope. First, the government failed to carry its burden to prove that police had an objectively reasonable basis to believe entry was necessary to provide emergency aid to some unknown gunshot victim. And second, the government failed to establish that evidence discovered in the backyard was observed in plain view while police were engaged in a strictly circumscribed search tailored to locate an injured person. So with respect to the initial entry into the backyard under the emergency aid doctrine, the government failed to provide the specific...
Let me ask you to focus on that question, Mr. Whitehead.
Yes, sir.
As I read the testimony, the police see multiple trails of blood leading up to the front part of the house, or maybe leading from the front part of the house. One trail of blood traced to your client, who was a gunshot victim. They followed another trail of blood down to Southern Avenue and found Mr. Thompson, a gunshot victim.
Yes.
And then they identified what they considered to be a third blood trail, which led around the side of the yard and was visible on the other side of the metal gate. Why wasn't it reasonable to think that that blood trail also would lead to a gunshot victim?
Well, I think that based on the testimony that the shootings of Mr. Brown and Mr. Thompson are merely a diversion here. I think that the evidence shows that any blood trail that leads to Mr. Thompson is limited to the sidewalk in front of Mr. Acer Lee's house, and that none of the evidence of his shooting or any other shooting directly links to Mr. Lee's property, especially his backyard. I think the blood trail that I I think the court was referring to, or the testimony referred to, that led within Mr. Lee's front yard area, whether it's to his door and then around the side yard, were blood droplets. And that was completely consistent with Mr. Lee's account and his injuries. And they didn't make any suggestion that the blood that they saw within Mr. Lee's property was anything but Mr. Lee's blood. Because the blood that led from Mr. Thompson to Mr. Thompson, as the Detective Evans testified, he was a hunter. He could tell the direction of those that particular blood trail. There was a pool of blood at several locations on the way to Mr. Thompson. So it's very apparent that this is a different blood trail, and that is coming from outside of Mr. Lee's.
You may think it's apparent now with the benefit of hindsight, but when the detective was there in this frenzied activity with lots of blood and lots of gunshot victims, why was it unreasonable for him to follow that trail into the backyard?
Well, because at that point, all of the victims, I mean, this was not a very fast moving situation at all. I mean, the detectives had already taken 20 to 30 minutes and beyond to go track down Mr. Thompson. And then when he got to the front yard, they take their time and through curiosity, see that there's a blood droplets that lead around the side yard. Now, when they get to the side yard and they see that there's this gate, they say that there are blood droplets that are on both sides of the gate. Now, it's not a situation where they say that this is consistent with anything other than Mr. Lee. In fact, the trial court finds that, well, of course there was blood. There were blood droplets on the side yard because that's where you would expect to find them, because that's where Mr. Lee said he was shot.
Can I ask you about the blood trail that goes to the blood that goes to the front door? Because I mean, it's one thing to say that certain pieces of information are consistent, but it's a slightly different thing to say it's fully explained. And so the officers kind of had what appeared to be a full picture of things. Was there an explanation that the officers would have had at that time, express explanation about why there was blood leading to the front door and on the front door?
Well, in terms of express, no, but I think that a reasonable officer would see that Mr. Lee, he tracks them down. Well, he alerts the police that he's been injured. He has a towel covering his right hand, his hand. They see that there's a blood drops that lead from where Mr. Lee is standing to the front of his house that go into his yard and around the side. So a reasonable officer would know, okay, Mr. Lee said, I was shot at the side yard. He flagged us down. He's been credible. He's a victim. He runs from his assailant. What's reasonable is that Mr. Lee then went into his house, obtained a towel, because that's something they wouldn't have had when he's letting his dog out, obtained a towel to address his wounds, comes outside.
I'm a little unsure. At one point you said that a reasonable officer would know, and that seems like a strong term for the story you're telling, which is what maybe, one scenario a reasonable officer might mean. But I thought the information was that your client indicated he ran from the area. And so are you saying that the officer would think, oh, he ran from the area, then at some point he circled back and he got those things, and there's a dog barking and maybe he took his dog back in? Or I'm a little unsure whether he's running from the area or he's going and putting his dog in the house and getting a towel to tend to his wounds.
Well, after
intention.
I'm sorry, Your Honor. After he initially says that run from the area, and then the court actually drills down on more specifics on what Detective Evans meant by when Mr. Lee says he ran. And then it seems to get more vague. He says that he ran from his assailant, and did the detective ask any further questions about where he ran, or did he go into the house? The detective says no.
No, I got all that. So there's a lot of information we don't know. I'm just trying to figure out what's the picture. The picture is he's shot while he's outside and he runs back into his house, and that's his running from the area, or he ran from the area and then later he circled back to his house. I'm just not sure which a reasonable officer would have to know was the truth.
Well, I think that it's unclear that when he said run from the area, that meant, oh, he ran away from his home, period. because he seems to clarify in later testimony when the judge starts asking him, oh, you said that he ran. Did he specify exactly where did he ran from? And there's no mention of running from the area. It's he ran from his assailant. But when you see that the blood droplets lead from the side yard, which again, the trial court said was consistent with what Mr. Lee said, to the front in that front porch area, and then there are more blood drops that go from the porch to the sidewalk to where Mr. Lee is standing, that yes, a reasonable officer, he didn't ask him any more questions, and certainly could have. I mean, Mr. Lee was perfectly cooperative and was with an officer the entire time that he was in an ambulance and at the hospital. But a reasonable officer would have, or there wouldn't have been a reasonable basis to believe that there was some other injured person in the backyard, not hearing anything. Mr. Lee didn't say that he said that there was nobody else at the house, and said that he was shot in his hand, and they have a towel there, which gives the strong impression that he went back into his house to get this towel to cover up his hand and cover up his injury. And that was something that he showed the police, along with his graze wound to his abdomen. Again, those things are fully consistent with the type of shots, or the type of injuries that he had, that there would be these, what the police described as these blood droplets. And they weren't photographed either. I mean, this wasn't a situation like Mr. Thompson where they have, blood in pools. They had these singular blood droplets that we would argue is fully explained, just as in Evans, where after you have an account from Mr. Evans and Miss Taylor, his girlfriend, about the domestic dispute that they had, that when the officer went to the apartment and saw that there was blood on the floor and an inviting apartment door that was open, that he could not have gone into that apartment without a warrant, because that blood had been explained by the injury and by the accounts of both Mr. Evans and Miss Taylor. And that's the exact same thing that we have here.
I'm having trouble with why you think the assumption follows that he went back into the house to get a towel. I see lots of people out in their yards, sometimes doing yard work with towels around their necks, for example. He could have had a towel with him outside. Why should police have thought that the blood going into the house was his?
I mean, I think that's anything is possible. If you let out your dog, I mean, maybe he was, it would be more consistent if he had a plastic bag to clean up after his dog, after they went to the bathroom. But for the towel, and certainly there was no question from the police about, where did this towel come from or anything of the sort. And there's no testimony that they necessarily questioned that this blood was consistent with what Mr. Lee had told them. They just happened to
case, and this case seems to me a harder one than Evans. The way the court viewed Evans, the police come to a scene, they see two people who, by each of their accounts, were involved in an altercation. They're given, differing versions of the altercation, but no indication that there is any third person involved. And the court ended up saying, well, it is always possible that the police don't have the full story, but they had an account that would explain fully what went on. And there's a dispute about who was sort of the aggressor. And the bare possibility that they don't know the full story or someone is lying to them is not enough to go into a house on emergency entry. This case seems harder. Whether hard enough is, enough harder is the issue in a way, but it seems harder in that there are a lot of, not just, well, it's possible that somebody's lying, but there are a bunch of unanswered questions that seem, how'd the dog get back in? Where'd the towel come from? Where are all these other blood? Why is he not mentioning any other shootings, even though there are shots fired in the area roughly, again, a little unclear where the area is and how contemporaneous, but there's just like a lot going on here that I think a reasonable officer would have had concerns about beyond just, oh, I have no specific reason to have questions, but it's always possible. So it seems like it's a harder case than Evans.
I think that there is a lot going on, and there's a considerable amount of investigation that the police would ultimately have to do. And I think what Evans says, and what it does say, is that, well, is it a situation where, by Mr. Lee's account, that the government presented evidence to show that he might have been lying to cover up for the fact that he was that somebody else was injured in the backyard. And that's simply not the case. And I think a good hypothetical would be, okay, so say Mr. Lee, he gives them the exact same information. And when the police look to the side yard, instead of seeing blood droplets, and I hate to be gruesome here, they see a severed hand. In that instance, unlike Evans or Wolf or these other cases, then there is something that is specific to the backyard that shows that Mr. Lee might have been lying to cover up the fact that somebody else is injured back there, because Mr. Lee shows up, he has both of his hands. We know that by seeing this severed hand that there's definitely a reasonable basis to believe that there's some other injured person that's into the backyard. That's not the case here. There's a lot going on, but again, Mr. Brown says he was shot in Southern Avenue by somebody that fits the description of Mr. Thompson. The police go to Mr. Thompson. He doesn't say anything about when and where he shot, and neither does Mr. Brown say when he shot. But Mr. Thompson appears to have shot himself in the foot. And the closest that he can get, or that shooting gets to Mr. Lee's house, is on the sidewalk in front of the property. But because there's no specific link that leads the police to say that not only did the shooting happen, or that there's some other evidence of some unknown fourth victim on Mr. Lee's property, but it has to be specific to his backyard. And that's simply not there. Again, the only evidence that shows that there's a possibility of an injured person in the backyard are the blood droplets that that are on, and specifically on, that side yard. And with Mr. Lee's account, it's perfectly consistent and also fully explains those blood droplets. So Mr. Lee doesn't have, it's not incumbent upon him to solve all crimes for the police. It's just does he give enough information that fully explains this blood that's on the side yard that could potentially lead to an injured party? And in this case, yes, he does. So when you focus in on that particular piece of evidence and where the side yard and what the police could possibly be thinking about whether or not there's an injured person, Mr. Lee's account and his injuries explain that blood. So I think what's also important is that the police didn't just violate the Fourth Amendment on the entry, but they also violated the Fourth Amendment in scope. And Mincy was very clear that you have to have a strictly circumscribed search, and it has to be tailored to the exigency which justifies that initiation. And in this case, the government presented no evidence. In fact, the evidence that they presented was that the police were engaged in a full-scale search. Nothing that, like Earl and this court in Harris have said, that a protective sweep is something that's an appropriate type of search that can be conducted to satisfy whether or not something is strictly circumscribed. And a protective sweep is quick and limited, a visual cursory inspection. It has to be carefully tailored, and the police
Can I ask you about terminology and the framework here? In Booth, I think we might use words like carefully tailor or narrowly tailor. I forget the adverb.
Right.
Then circumscribed is another term that's floating around. And
right.
In Brigham City, there's really not any reference to a scope type requirement. There's a general requirement under the Fourth Amendment that searches be reasonable in scope. So do you find any differences among the search would have to be reasonable in scope? It has to be narrowly tailored. It has to be reasonably circumscribed. Do you think all of those are the same and it's not critical which label we use, or do you think there is one that is different that we are required by law to follow? What's your take on that?
Well, I think that there's two. Really, it's strictly circumscribed because Mincy is not about entry. Where a police officer was shot in a home, the entry to conduct an emergency sweep was certainly permissible in that case. The issue was whether or not there was a homicide exception and the police could just hang out for 4 days without securing a warrant. And in that case, that's where the language comes from, strictly circumscribed by the exigency that justifies the initiation. And this court in Booth, kind of took from that and discussing tailored carefully. The police can do no more than is reasonably necessary to ascertain whether or not there's an injured person. So there's all these different permutations of that. But I think what it does is it really drills down on what's important here, and that this has to be a very narrowly tailored search, and it cannot go into this full search. There's a discussion within Earl and Harris about how protective sweep, visual cursory inspection, and that's exactly opposite of what the officers did in this case. The manner in which they conducted their search in the backyard is so material, and the way they discussed their search in the backyard is just canvassing, looking for evidence. Multiple times so they talk about their search in the backyard is just canvassing and looking for evidence, and that's how they come upon finding very tiny and minuscule pieces of evidence. This isn't a situation.
Can I ask you a possible distinction? Because the picture you paint is kind of like a protective sweep in a house. The police are looking for a person. They go inside and they can't start really microscopically looking carefully around. They kind of cast their eyes around to see if there's anything big enough to be a person. If not, they'll go to the next room and then get a warrant or secure the premises or whatever is appropriate. But it is a little bit different, at least arguably, if the way the police are getting to the backyard, what they're doing is they are tracing a blood trail, because that does mean that you're not just kind of looking, oh, is there someone in the backyard? You might be looking like, where does this blood trail lead? Maybe it leads out the backyard and I need to follow the blood trail as part of the exigency. So it's a little, I'm not sure it explains a full canvas of the area, but it isn't a little bit different if they are, assuming it's lawful for them to go in at all, which I know you dispute. Do you agree that it would be lawful for them to carefully try to follow the blood trail without just kind of casting their eyes around generally to look through the area?
That might be the case, but I think that the record doesn't show that. I mean, it was the government's burden.
I mean, as you said before, anything might be the case. I'm a little curious whether you agree that it would be the case.
Well, I'll put it this way. Even if it were the case, the record shows that the blood trail actually ends on the side yard. It's very, because the gate itself is somewhere in the middle of this side yard that extends the length of the house. And that's to the appendices that both myself and the government submitted. That the detective testified that the blood droplets were on both sides of this gate, but that they only extended to the side of this porch. And it was very clear that the blood drops or trail, however you want to characterize it, ended before the police got to the actual backyard, and they were not in a position to see the bullet or the shell casing that was on the ground. In fact, what the record is clear about is that the bullet and shell casing were found after 5 minutes or so. And so, as we said in our briefs, this is a small DC open row house backyard, and the government didn't present any evidence otherwise. And it doesn't take 5 minutes to search. I mean, they immediately found that the blood trail ended on the side yard, and it doesn't take 5 minutes to search this area and do a sweep to find if anybody's there, or that the end of the blood trail is there, because they find that almost immediately. What it takes is just a few seconds, and I think the best way is to have a contrast with how the detectives, because they knew how to testify and conduct a proper sweep for purposes of the emergency aid doctrine. They used, taking a look at their language, they talked about entering the interior of the house in terms of a protective sweep. They discussed going through 3 floors of this house with multiple rooms on each floor. You have small, intricate areas like bathrooms and closets. You have furniture. They did this whole search within 3 to 4 minutes, and then shut down the operation once they found out within the scope of the search that there was an open bag of drugs on the bed. And that's in stark contrast to the way that the police conducted their search in the backyard, which is canvassing for evidence, just looking around, and lo and behold, there's some really minuscule pieces of evidence that are on the concrete pad. They look up where nobody's going to be hanging around. If they were looking for a bird, maybe that they were looking to the second-story window and find a bullet hole. And then there's a singular blood drop that's on the back porch. By then, they would have long found that there was nobody that was in need of emergency aid, and they should have shut down their search as soon as they determined that there was nobody there. And that was something that they did not do. It was something that the government did not prove that the plain view doctrine applies here, that even if these items were in plain view, They did not prove that they found the items within the strictly circumscribed search. This cursory visual inspection, where the police did no more than to reasonably to ascertain whether or not there was an emergency and that there was somebody that was there that needed help. So for
Mr. Whitehead,
yes, ma'am.
go ahead. No,
No, I'm
go
sorry.
ahead and wind up.
Oh, okay. I see my time is long expired. I would respectfully ask that this court reverse.
Thank you. We'll give you a couple of minutes on rebuttal if you need them. Thank you.
Thank you.
Mr. Hansford, please.
Good morning, and may it please the court, Eric Hansford for the United States. I'll focus on the backyard search as well, since that's where the focus has been in appellant's argument. And I think the key here is what the police were seeing on the scene was not explained by the defendant's account. The defendant said he was shot in the side yard and the police saw a blood trail going into the backyard. The defendant said he ran from the area after being shot, and the police saw blood on the front steps of the house. The defendant's account only included his shooting, and the police saw that there had been a shooting directly in front of his house. That's Brandon Thompson, that the defendant didn't mention. And I think it's important in framing all of this that the defendant's own account was of a masked gunman coming up to him in his side yard and randomly shooting him. So this is not like the Evans situation where you have a domestic dispute, every reason to think it's just these two people who would be involved. The defendant's account instead suggests a very dangerous situation where there would be reason to fear further victims in this case. In terms of whether or not the account included just blood in the side yard or into the back, I think the record fairly and pretty clearly demonstrates that the blood trail that the police saw and described went into the backyard. Can
I just ask you about, you say went into the backyard. I want to make sure, is it your view that the officer's testimony was, I could tell the direction of travel of the person who is bleeding? Because I thought the testimony was more coming from, at least with respect to that trail, couldn't really tell what the direction of travel was. Is that true?
That's correct, or at least he didn't make a determination on that. So yeah, you didn't know which way the blood was traveling. But the testimony was on page 92 that the blood appeared to go around into the back of the location. On page 103, the droplets appeared to be going towards or coming from the back of the location. So he's not just describing a shooting in the side yard. What he's describing is blood in the backyard.
Can I ask you a framework question too?
Yes.
The parties seem, I think everybody agrees that the standard we are required to apply here is whether the police had a reasonable basis to believe or some formulation of those terms.
Right.
But there does seem to be a dispute about whether that phrase in turn is properly understood as we had held in cases like Booth to require probable cause, or
Right.
whether it authorizes some lower basis of grounds for belief.
Right.
Am I right in thinking that you believe that a division of the court is free to not apply the probable cause standard applied in cases like Booth, and instead apply some standard that is less demanding?
We do think that the objectively reasonable basis standard is a lower standard, or is a different standard from probable cause. We think it differs in a couple of ways. And in terms of whether the panel would be free to recognize that, the Supreme Court, I think this court recognized in Ball, it selected the objectively reasonable basis standard, even though the Supreme Court obviously knows how to articulate a probable cause standard.
Well, it also knows how to articulate a reasonable suspicion standard, and it is used, unfortunately for us, it is used phrases like reasonable basis to believe to communicate both of those standards. So I'm not sure that I am with you if your point is just by picking the words reasonable basis to believe, we know whether probable cause is intended by the Supreme Court or not.
I think we can say it is not, the Supreme Court did not select the probable cause standard. And then
nor did it select a reasonable, or it selected terms that it is in some cases equated to probable cause. Do you agree with that?
I think it can be equated to probable cause. It can also be equated to lower standards, as the court recognizes. And so I think the question is then, what does it mean to have an objectively reasonable basis? But I think that's a secondary question from whether or not this panel is bound by prior decisions saying probable cause. In terms of how we think objectively reasonable basis compares to probable cause, we think it differs in a couple of ways. One is in how it applies, and the other is in the quantum of proof. So in terms of how it applies, the Supreme Court in Ryburn v. Huff, applying this standard, explains that courts should be wary of second-guessing police determinations of whether or not this is a dangerous or emergency situation, and that the police are forced to be making second decisions, and therefore there has to be some deference to that. And I think that is not typically what you would find in a probable cause or reasonable articulable suspicion analysis. Normally, that's just seen as a kind of line in the sand. It's not a deference to police forced to make split-second decisions. And then the other difference is in the quantum of proof, which is that this court in Evans recognized that, said that the 10th Circuit had suggested probable cause is a higher standard of proof. The First Circuit had said it was equivalent. Since then, the First Circuit, in a panel decision, has said no, objectively reasonable basis is a lower standard. So we agree there's no consensus on there being that probable cause is a higher standard, but we think that is where the courts are moving, especially the federal courts. In this
Counsel, let me first apologize to both counsel. I was not taking a nap. I got disconnected. But let me ask you more about the quantum of proof, which was something I was about to ask Mr. Whitehead. The Supreme Court in various cases has said that the probable cause standard is not all that high. It's certainly not preponderance of the evidence. There doesn't have to be certainty in order to have probable cause. Do you think this case turns on whether we apply the probable cause standard or the reasonable articulable suspicion standard?
No, we don't think the standard ultimately matters for the outcome here. I do think that the standard is creating some confusion. I think Evans and Ball were fairly clear that objectively reasonable basis is the standard, and how it compares to probable cause is an open question. We do think it's creating some confusion that some courts are still sticking with the original probable cause articulation and not recognizing that objectively reasonable basis is the test. But we agree the court does not have to resolve that issue to resolve this case.
Let me ask you then about objectively reasonable basis.
Sure.
One of the interesting things about this case is the amount of time that elapsed before the police entered the backyard and the additional time that elapsed before they breached the house. Does that delay go to the objective reasonableness of their entries?
I don't think it does. And indeed, I think the Seventh Circuit, in the case we cited, whose name is escaping me at the moment, talks about how when the police in that case are making entry into the backyard, the fact that a couple of hours had elapsed since the shooting, that actually suggested a higher level of emergency because someone could be bleeding out at that point in the backyard. And so we do not think that it undermines the police actions, especially in this case where you've got the police following blood trails. It's not as though they're sitting there twiddling their thumbs. They're following blood trails to try to determine if there are other victims, where you have 3 shootings in a very close area where the defendant is describing this as a random shooting with a masked gunman. And so we think that does support, we think it supports or certainly doesn't hurt the entry in this case. And I think you also have cases like Michigan v. Fisher, where the police arrive, see the defendant kind of ranting inside of his house, It's unclear when exactly his injuries would have occurred, but the police still say objectively reasonable basis to go in. It doesn't have to be seconds after the shooting. And if there are, I did also want to touch on what the police did when they got into the backyard, which is that the description of the police taking 5 minutes to find the evidence is not accurate, is not supported by the record. What the record says on page 160 and then 162, once the detective says he's in the backyard for 5 minutes or so, the other time he says he's in the backyard for a couple of minutes. But the testimony is about how long he's in the backyard, not how long he's searching before finding the first piece of evidence. And I think it would be hard to imagine it taking 5 minutes to find the shell casing and the bullet that are out in the open.
Can I ask you another framework question?
Yes.
What standard do you think we should be applying in determining whether or not the scope of the search was lawful under the Fourth Amendment? Is it a narrowly, carefully tailoring standard? Is it a strictly circumscribed standard? Is it what do you believe the legal test is that governs this part of the inquiry?
We think it's a reasonableness standard, and the Supreme Court in Brigham City explicitly notes that the manner of entry in that case was reasonable, and the 10th Circuit in the Gambino-Savolio case that we cite has said the second part of the test is whether the manner and scope of the entry is reasonable. So we think it's
and what do you make of your opponent's reliance on at least the phrase carefully circumscribed in Mincy?
So I think a couple of things. First, we think Arizona v. Hicks explicitly deals with that phrase and says that when there are items that are out in plain view, the police are not expanding the scope of their search when they're looking at those items in plain view, even though in the Arizona v. Hicks case, it's a potential stolen stereo completely unrelated to the shooting emergency that the police are responding to. So I don't think it's correct that the police are precluded from kind of looking closer at things that they see in plain view when they're in a place that they're allowed to be. But I think the more fundamental point is the point that Judge Grice was making earlier, which is that the police here are not just looking for an injured person. What they're trying to resolve is whether this new blood trail that they see going into the backyard, does that represent a fourth victim or not? And what they need to do to resolve that is to look at the very pieces of evidence that they ultimately find. It's the blood drop on the back door, the shell casing, the unspent ammunition that suggests to the police, oh, this is in fact the site of a shooting, not a place that a fourth injured victim passed through, and therefore we should be following the blood trail the other way. But I think in order to resolve what to do about the blood trail, which is what's justifying entry into the backyard, the police do need to be looking at exactly that evidence. The police cannot just look and see if there's an injured person, because it could be that someone went into the backyard as the blood drop next to the back door indeed suggested in this case. That's what the police had to resolve in this case.
You started out by saying that you were going to focus on the backyard because Mr. Whitehead had done so.
Yes.
Have you in fact waived any argument that the entry into the house could be separately justified?
No, and I'm happy to address those questions from the court. So we think that the entry into the house, there are two alternative bases for upholding that in this case. First is the emergency aid doctrine.
Excuse me, counsel. I thought I saw a footnote in your brief that said, if we lose the entry into the backyard, we're not trying to save the search of the house.
I'm sorry. We are agreeing with that. I understood Judge Thompson's question. Maybe I misunderstood it to be if the entry into the backyard is valid, can the evidence come in? But we agree that if the entry into the backyard is invalid, we are not arguing that the evidence recovery would be valid in this case.
And what's the logic of why are you not contesting that? If your argument is you could win even under a probable cause standard in the entry into the backyard because blood led there, doesn't blood also lead to the front door? And so why isn't the logic of your argument that you actually also could lawfully have gone in the front door first or without doing anything in the back?
I mean, I don't want to
really
get
where
into
my
internal
question
deliberations about why we're making the arguments, but I think that the record.
Well, no, I'm not interested in your internal deliberations.
Sure.
I'm just asking logically, can you explain why you think the evidence is stronger to go into the back following that blood trail than the evidence going into the, that led to the front door?
I think we have a fruits problem with the backyard in terms of the police did go into the backyard first, and they described based on what they were seeing in the backyard going into the house. So it's not conceding.
Got it. So am I right in understanding that you're leaving aside the question of fruits and what actually happened here? Your view is there was probable cause for the police to have gone right in the front door for the same reason that there was probable cause in your view for them to go around back. Is that your view about? Yes. Okay. Thank you.
Yes, that is correct in terms of yes, that's correct.
Thank you.
Yeah. And so we do think if Judge Thompson's question was addressed to what happens if the backyard search is valid, is the rest of the house search valid? Was that the question?
Well, my question really was the question addressed by your footnote, and where I was going was to the question that Judge McLeese just asked you, which is what is the logic of that? Because there was blood on the steps going toward the front door, and you say there is a fruits problem. Explain that for me, please. I know what the officers testified to. You say there's a fruits problem because of their explained rationale.
Well,
What's
so
there?
Yeah, I think the problem is we would get into inevitable discovery questions in terms of if you have the backyard search being invalidated, is it nonetheless inevitable that they would have gone into the front door? And I think there could have been a record that would have supported that argument. And we do think there would be an objectively reasonable basis for going in. But I think in this case, when the police were articulating why it is that they ultimately chose to go into the front door, they were focused on, they were describing what it is that they saw in the backyard. And so we're unable to prove that the police would have still gone into the front yard in light of this record if they hadn't gone into the backyard. And
So let me ask you further about that. And I'm going to eventually lead to the search warrant and the inevitable discovery arguments. Have you touched on those yet?
no,
Okay. The cases mystify me about how we're supposed to look at this search warrant and apply inevitable discovery or independent source. But one of the ways I've looked at it is to carefully examine the affidavit, take out everything that refers to the entry of the house, take out everything that refers to the backyard, and turn it into a search warrant for blood and DNA evidence. I thought the detective and the sergeant testified that in a case like this, they would seek a warrant for the house to collect evidence, not bodies, but evidence. And why didn't they have probable cause? Well, let me put it this way. Is it your position that the police would have had probable cause to seek a warrant to collect blood and DNA evidence from inside the house? Forget drugs, forget weapons, we're after blood.
yes. That is our position. I think the issue we run into is when you get into the Murray analysis for independent source, which I think is the most on point analysis. is there's a two-prong question. Prong two is what you're describing. Would the magistrate be issuing the warrant without any potential fruits being discussed, unlawful fruits being discussed? Prong one is, are the police going to go into the house no matter what? And that's where we saw the record as lacking in this case, because when they're asked why it is that they were going into the house, they described what they had seen in the backyard. I understand I'm pushing back on favorable questions from the court, but I did just want to explain why it is that we took the position that we did.
Help me with the phrasing from Murray about, did it affect the decision? What does that mean?
So
Does it mean that with the illegal evidence, illegally obtained evidence included in the affidavit, it was an easier call for the judge to issue the warrant? Or does it mean undermine the legal basis for a warrant?
I think it's, when you're on that prong two, I think it's undermined the legal basis. It's not how much the judge would have hemmed and hawed about it beforehand. It's whether it does undermine the legal basis. But
So
I think
if I'm understanding correctly, you say your problem is you don't think the evidence shows that the police would have gone into the house anyway, looking only for blood and DNA?
right. I think we don't want to have this be a concession that would kind of affect the other analysis. We're just choosing not to press the argument that the police would have gone into the house nonetheless, based on the record in this case. We don't see that concession or that decision not to make a certain argument as affecting any of our other arguments in this case. I think there's also an element of, we don't want to fight the trial court who's granting our motion on every stage of the analysis as well.
So I may be a little obtuse this morning.
I'm
but
sorry.
Why do you still think inevitable discovery works if the record doesn't show the police would still have gone into the house?
So we think, let me just say one other consideration that's coming in, which is that it's not clear that we were making the argument below that we still would have gone into the house. So I think we also have a forfeiture argument if the backyard search is invalid. So once the backyard search is valid, that's where we're arguing inevitable discovery, independent source. And we think the record does support that the police, based on what they were seeing in the backyard, would have still gone into the house in this case, because that's both officers testified. There were policies in place about that, seeking a warrant in these sorts of circumstances. And so we do think it's satisfied once you consider the backyard evidence in this case. And that is what the trial court ultimately credited in this case.
Thank you.
If there
Thank
are no
you.
further questions, we'd ask the court to affirm.
Thank you, Mr. Hansford. Mr. Whitehead, we'll give you 2 minutes.
All right, thank you, Judge. I think the government made a lot of concessions right there. That independent source is the appropriate way to analyze this case. I would also point to, Judge Thompson and Judge McLeese's question about the logic of not challenging or not challenging the entry into the home. And I think that's an important distinction to make. They never made that argument that there was still probable cause to enter the house without any of the backyard evidence, that the blood trail allowed the police officers to go into that house until oral argument. And I think that speaks to also the side yard, that there is no probable cause to go into that side yard, irrespective of the shootings that took place, because again, there's no connection to the backyard specifically with the other shootings. And I mentioned probable cause because just to correct the government, as late as Ball, this court has said that Oliver has equated probable cause to the reasonable basis to believe standard, and citing how it fits well with a perceived emergency in contrast with a basis to prospective arrest, for which probable cause is traditional language. And this court and the Supreme Court has never explicitly said that there is a difference of standard or quantum of evidence between probable cause and reasonable basis to believe. Oliver completely goes through an analysis as to why it makes sense that probable cause is equivalent to reasonable basis to believe. With respect to the clarification on the amount of time that it took the detective to find evidence, well, first of all, the government seems to suggest that just because there are blood drops, that they have an opportunity, and the emergency aid exception allows them to go search for all kinds of evidence. And once they find that evidence, then they can make more determinations. But that's not what Mincy and that's not what Booth require something that's strictly circumscribed. And it took 5 minutes or so, and this is on page 160, as the government said. The witnesses asked how long it took to spot the bullet casing and the ammunition. The answer was, I don't recall it taking that long to find. We weren't out there for 15 to 20 minutes, maybe 5 minutes or so. And so when you look and contrast again between the protective sweep that was conducted inside the house, 3 to 4 minutes, and what it took 5 minutes or so of just canvassing and searching for evidence, it's the government has not proved their burden that the evidence found in the backyard was appropriately viewed within plain view while they were conducting a strictly circumscribed or tailored carefully search that was specific to looking for an injured individual. I see that my time has expired again, so I would respectfully request that this court reverse.
I'd like to ask a question, and if it's been asked and answered before, please tell me. In comparing this case to Evans and some of the other emergency aid cases, how do we factor in the fact that here we're dealing with potentially lethal criminal activity, as opposed to a domestic dispute where people are punching each other or slapping each other, that sort of thing? The risks here are very high when you're dealing with gunshot wounds. Does that affect our analysis of whether there's a reasonable basis to believe that emergency aid is required?
No, Your Honor. I would specifically point to Wolf, US v. Wolf, which was actually cited in our opening brief and also cited in Evans. In that case, there was a call for a shooting, and when police arrived to a particular home, they found that the victim was inside of his house. There was a call for shooting outdoors. And once the victim said, as well as the other individuals in the home, said that there was a shooting that took place outside. There was blood everywhere inside of the house. At that point, the detectives could not have gone any further. What happened was that another officer came, saw that there was blood leading up the steps of the home to the second floor, which that officer followed that blood trail with the expectation or belief that there was some type of injured person up there and found narcotics or found contraband. And the Third Circuit said that was an invalid search, because even though that there was both things that were present here, which are gunshots and blood trails, that the information that the police had at the time that they saw that blood trail going up the steps, everything had been fully explained by the individuals that had already been interviewed by police. The shooting happened outside. The victim had been accounted for and said that the shooting happened outside, and they said that there was nobody else inside. And in the same event, Mr. Lee said he was shot on the side yard, had his bloody hand. The blood droplets were considered consistent with what he said, and he said there was nobody else at the house. And that, for that reason, it doesn't matter that there were gunshots or blood involved, that the police should have stopped and should not have entered. They did not have a reasonable basis to believe.
How do you explain Mr. Thompson? He had been shot and he had been at the house. The blood trail tells us that. So your client's explanation about where he was shot doesn't end our inquiry.
Well, I think Mr. Lee he's not obligated to solve their crime. I mean, I think what's not there within the record is when Mr. Thompson was shot or what the circumstances for which he was shot, so that Mr. Lee would have been expected to know. And there's not only just an expectation to know about Mr. Thompson, but it has to be one that there's an omission to suggest that he's lying to cover up that there's somebody injured in the backyard. Mr. Thompson's shooting, the evidence is it happened not just in front, but on the sidewalk. So not even on Mr. Lee's property, because that's where the fork in the road in terms of blood trails exists. It's on the sidewalk in front of Mr. Lee's property. And only that from there does it lead to Southern Avenue in Maryland, where Mr. Thompson is located, where there are pools of blood. And there's no suggestion that the blood trail that leads from the front sidewalk to Southern Avenue is consistent with the blood droplets that's within Mr. Lee's property, because the hunter in Detective Evans discusses how you can see the direction, there are pools, and doesn't make any type of suggestion that there's the similar characteristics to the blood droplets that are within Mr. Lee's property leading up to his front door or going around the side yard. So if the court has no further questions, I would respectfully ask that this court reverse. Thank you.
Thank you, Mr. Whitehead, and thanks also to you, Mr. Hans, for the cases submitted. And the last case on the calendar is number 19 CF 0438, Gregory Patterson versus United States.
Articulable suspicion. I'm going to take into account the fact that the guy really doesn't want me to search for his car. Is that permissible?
So, Your Honor, we think it does have evidentiary significance. Well, let me answer each part of your question.
Getting
So,
some
first of all,
interference.
we think that it does have evidentiary significance on the Fifth Amendment question.
I don't care about the Fifth Amendment.
Okay.
I'm talking about the Fourth Amendment.
Mr. Brannon?
Can you hear me?
And the question specifically is whether
Pembroke.
Whether that can be factored in as
Ms. Pembroke, can you hear?
maybe not by itself.
Yes, just a moment, Your Honor.
All right. Mr. Brannon, we're getting a recording of another argument, I think.
Yeah, she needs to cut off the YouTube. Cut off the YouTube.
I did, I just did, I'm sorry.
Okay, all right, that's what it was. Okay.
Everyone can hear now?
I'm sorry, Your Honor?
Okay, you can hear us now?
Yes, I can.
Yes, all right, thank you. I think we're ready to proceed then, Ms. Pembroke.
Okay. I'm sorry, Your Honor. I didn't realize that the court was ready to move forward.
No problem, quite all right, thank you.
So my name is Christine Pembroke. I know it says Gregory Patterson on the screen. I apologize for that. That's my client. And I am here to discuss with you the challenges we have to Mr. Patterson's convictions based on the Fourth Amendment. We maintain that Mr. Patterson's convictions should be overturned for the reason that the police had no reason to believe or had no articulable basis for believing that he was engaged in or about to engage in criminal activity, or a reasonable basis to believe that he was armed and dangerous. Looking at the totality of the circumstances surrounding the stop of Mr. Patterson, there are a number of indicators that he was not engaged in any criminal activity. He was walking along, minding his own business, watching a video on his iPhone. He was not engaged in any furtive gestures. He didn't try to flee. He wasn't nervous. Even though the police ran up to him in almost an accostive type way and started questioning him very loudly about whether or not he had a gun, he behaved very calmly in response to all of that, and just sort of asked them what was going on. The government has argued in its briefs that the sound of a gunfire in the area on the shot spotter technology was a basis for the police to believe that Mr. Patterson had a gun. I think there are a number of problems with that argument. The first is that it's not
Before
really
you get into
clear.
the details of that line of thinking, I want to just make sure we're in the right framework. Are you arguing that there was no objective, reasonable, articulable suspicion to believe that your client was committing a violation of the possession of an open container of alcohol law, the POCA?
Well, initially, there wasn't, because Officer Rogers wasn't close enough to him to have smelled any alcohol. But I think there are a lot of concerns about this allegation that he was being stopped for a POCA violation. First of all, it never came up at the time of his arrest. He was not arrested for that. This came up as sort of an ancillary thing at the suppression.
I know I know you were making in the trial court, and I think you made to a degree in your brief in this court, an argument that even if there was an objective basis for a POCA stop at the time of the stop, that wasn't really what was going on, and that might affect the legality of what happened. I'm just trying to make sure whether you are arguing, because I didn't really see it in your brief, so I'm curious whether you were arguing separately, the kind of the distinct point at the time of the seizure here, the officers, are you arguing that at the time of the seizure, the officers did not have objective basis on which they could have stopped him for your client for violating the POCA law?
I think there's a real problem with, I'm sorry, my screen is sort of off here. I think there's a real problem with claiming that there was an objective basis for the POCA, because, and this was never argued at the suppression hearing, but if you go and look at the videos very carefully, it's difficult to tell. And I don't think that my client was actually in a public place consisting of a street, alley, park, sidewalk, or parking area.
Is that an argument that you included in your brief or your reply brief in this court?
I did not get into that, Your Honor, because I think that our theory was that he was not being stopped for a POCA violation. But I think that there was not enough on the record below to substantiate that that was a reasonable basis for the stop, because if you look carefully at the videos, my client is standing in sort of a dirt area that's beside a fence adjoining the back of what looks like an apartment building. There's a dead tree stump of some kind near him. He's behind a dumpster. So I don't think that where he was standing constitutes an area that is prescribed by the POCA statute as an area in which drinking cannot occur.
Ms. Pembroke,
Yes.
I might agree with you that I'm skeptical the police ever thought about stopping him for a POCA violation. But what I'd like to understand is how you deal with the Supreme Court cases such as Wren and others, which seem to say we don't care what the police thought, so long as there is an objectively reasonable basis supporting what they did. Are you arguing for a change in the law, or you have a way of distinguishing Wren?
No, I don't think, I think Wren is correct. I would concede, Your Honor, that if they have an objective, reasonable basis, whether or not they were actually relying on that, they could. But I am concerned that the record here does not demonstrate they did have that, because I don't think he was in a POCA area.
Okay, but will you agree that at some point they knew that he had in his hand a styrofoam cup that contained alcohol.
Yes, Your Honor.
And you quibble about whether that was connected to the display of materials on the roof of the car or the hood of the car.
Well, I think the problem with the government's theory that the fact that Mr. Johnson had a gun and Mr. Johnson was partaking of alcohol, and therefore it could be inferred that my client was interacting with Mr. Johnson, and there's some reason to believe that drinking partners also are mutual gun possessors. The real problem with that.
I'm interested in a different question.
Okay.
Was there a reason to believe that your client had been drinking from the array of things that were displayed on the car?
Well, the concern I have with that, Your Honor, is that Officer Rogers did not know, I believe, that there was an array of drinking materials on the hood of the car by Mr. Johnson. Because if you look at the videos very carefully, you cannot see what is on the car near Mr. Johnson at the time that Officer Rogers is interacting with my client. I know he testifies that he was aware that a styrofoam cup and alcohol were found on the hood of the car by Mr. Johnson, but that those items were completely obscured by Officer Hillier, the darkness, the distance. You cannot tell what was going on the car near Mr. Johnson at the time that Officer Rogers was interacting with my client. So Rogers had no knowledge of there being alcohol over by Mr. Johnson.
And in your view, you're making that point as relevant to the question of whether there were connections between Mr. Johnson and your client that affected the significance of the discovery of a gun on Mr. Johnson, because if they're, in your view, the officers would have not had a good grounds to think they were suspected, then a gun on Mr. Johnson is less relevant to how the officers are dealing with their client. Is that right?
That's correct, Your Honor, but I also address, I think, Judge Fisher's implication that there was some basis to believe a polka was going on in the sidewalk by Mr. Johnson.
Oh, I see. I was wondering, that's why I was going to ask, are you also, though, making yet a different argument, or you're, I guess, developing further the argument that there may not have been reason to believe there was a polka violation because your client might have been on property that was not covered by a polka statute. And although there was another car that maybe inferentially was in a different location, there wasn't sufficient reason to believe your client was connected with the location of that car. Is that the point you're making?
Yes, the Officer Rogers had no knowledge whatsoever at the time he was dealing with my client that there was alcohol by Johnson.
Can I ask you?
And does it matter that the other officers saw the array of things on the car and knew it?
Well,
Is this
I
a
think that this
collective
court
knowledge situation?
I'm sorry, Judge Thompson, I didn't mean to interrupt you. I think that this court has addressed the issue of collective knowledge very recently in a case called Ellison. And in that case, what the court noted in a footnote on page 13 of the slip opinion is that the knowledge of other officers does not support the decision of the arresting officer unless that information was communicated to the arresting officer at the time of the arrest. So this information was not communicated. But there's a second problem with applying the collective knowledge.
Just before you move off the footnote in Ellison, I thought the footnote in Ellison said there are different formulations and the court wasn't going to decide exactly what all is required under the collective knowledge.
I didn't mean to suggest that the court had decided that issue in Ellison. They sort of avoided it, and I agree.
Can I ask you about this topic more generally, because it's all quite interesting and collective knowledge is an interesting wrinkle on it. But one thing I struggle with about it is I didn't see anything on this issue in your opening brief in this court or in your reply brief. So this is all kind of coming without any real briefing, and we don't ordinarily allow folks to raise arguments for the first time at oral argument. So do you think we should make an exception, or do you think it was in your brief, or how do you deal with the fact that this is kind of developing for the first time at argument, it seems.
Well, I don't think this is a new argument. It's part and parcel of the Fourth Amendment argument that has been raised. And I'd be happy to submit supplemental briefing on this issue if the court is interested in it. There's one other primary problem I have with the collective knowledge theory being applied here, and that is that it applies only when the officers are investigating the same case. And in this case, the officers were investigating different cases. So the knowledge about the investigation of Johnson cannot be really applied to Mr. Patterson here.
They're different cases because there are two different individuals that they're dealing with?
Yes, Your Honor, and they were charged separately. There was no attempt to charge them as co-defendants. Clearly there was the different cases involved.
I think that's a stretch, if you'll forgive me. They're trying to figure out what these two guys are up to.
Well, but they weren't talking to each other. They weren't interacting. It's kind of odd to assume that the two of them, not knowing that there was alcohol on Johnson's car, were even associated with each other in any way. So I don't think it wouldn't have been reasonable for Officer Rogers to presume that there was any connection with Johnson. I know that Lewis talks about assuming a reasonable assumption that someone in the immediate vicinity of a person found with a gun may also have a gun, but these two individuals were not in the immediate vicinity of each other. The trial judge says that, there's at least 20 feet, if not more. From the videos, it looks like there's maybe 30 feet between the two of them. Mr. Patterson was engaged in a completely unrelated activity. He's watching a video on his phone. He's not communicating with Mr. Johnson. He's not even looking in Mr. Johnson's direction. And when he's told that a gun is found on Mr. Johnson, he's sort of shocked. He's just totally surprised by that. He didn't even know who Mr. Johnson was. When Officer Rogers said, "We found a gun," he responds, "Where did you find a gun?" He said he had a gun, and he was, who had a gun? He didn't even know who Officer Rogers was talking about. So I think it was a stretch for the police to assume that there was any connection for Officer Rogers to assume there was any connection between the two of them. Are there any other questions about the connection between Mr. Patterson and Mr. Johnson?
I think you can go on with whatever other points you want to make for us.
So the last thing I'd like to talk about is the bulge in supposed bulge in Mr. Patterson's waist area, because the government has relied on that as a reason for stopping Mr. Patterson. And again, in this instance, there was not enough testimony provided below to support the conclusion that it was reasonable to believe that the bulge on Mr. Patterson was a gun. Officer Rogers did not testify about the firmness of the object, whether the object appeared to have any kind of weight, the contours of the object, the relative size of the object. He simply said that there was a bulge around his waist area that was not consistent with human anatomy. And I think this court's case law is pretty clear that that's not enough to jump to the conclusion that it's not an innocent item. And that it's a gun. And so
your
for all
opponent argues that it may well, perhaps you're right, that given some of the details you're mentioning that were not included, it by itself would not have been enough, but that our inquiry has to take that for what it's worth and add it to the various other circumstances that the government relies upon, and then and the trial court relied upon to add them all up. And you agree that's the right mode of analysis, that it's not, we don't look at the information about the bulge in isolation. We look at it with its limitations and figure out what weight to give it in combination with everything else that is present here.
Absolutely, Your Honor. And that's part of our point, that the totality of the circumstances here just don't support a reasonable inference that Mr. Patterson had a gun. He's not, there are a few things which might be suggestive of some kind of criminality, but there's a whole host of things that also are not suggestive of that. And on balance, it's just not reasonable to assume that he would be armed and dangerous and needed to be patted down.
If you were going to point us to a case of ours or a case out of jurisdiction that you think would be factually comparable enough that it would has a set of circumstances that are similar or that seems comparable in the quantum of information the officers had that you think supports your argument, where would you point us to kind of a factually comparable case that would help persuade us that you're correct, that we're short of the articulable suspicion requirement?
I think the Singleton case is probably the strongest case because even though the court found there that there was a reason to stop Singleton, they sort of said this is the bare minimum that the government has to have, and there was other things going on. Fear to sort of a holding of the area, gesture, nervousness, looking back at the police. Given that none of that was going on here and all you have really is a bulge, I think that Singleton is very persuasive in this context.
Ms. Pembroke, your time is up. We'll give you a couple of minutes on rebuttal if you need it.
Thank you, Your Honor.
Mr. Carroll.
Thank you. May it please the court. My name is Ethan Carroll and I represent the United States. I'm going to start by just mentioning the things that weren't in appellant's brief or reply brief and were raised for the first time in argument, and just make clear that it's the government's position that those are arguments that are not properly considered for the first time now. Those include that there was no reasonable articulable suspicion to stop appellant in the first instance, that the collective knowledge doctrine would need to be applied or would not apply in this situation, that there was any issue with whether Officer Rogers knew about what was on the hood of the car where Johnson, appellant's associate, was, and also that there was a 20-foot distance between appellant and Johnson. None of those things are in the record. None of those things were argued by appellant below, and they're not properly considered now.
There was something about the distance, wasn't there? I can't remember whether it was 20 feet, but there was some distance point made.
20 feet is the right distance, but it was the distance between Rogers and appellant, not the distance between appellant and Johnson. So that's just a misstatement that it was the distance between appellant and Johnson. Contrary to the arguments that appellant is raising for the first time here, the police had reasonable articulable suspicion to seize appellant based on the bulge in his waistband, a bulge protruding from his waistband. Even if the bulge alone wasn't enough, as Judge McLeese just articulated, it's not just the bulge looked at alone, it's the surrounding circumstances as well that provided reasonable articulable suspicion. The fact that this was a stop at 10:30 at night in a high crime area responding to the sound of gunshots and after having found appellant's companion in possession of a firearm.
Why do you use the word companion? That does seem to wrap around to contested questions.
Sure, I'm happy to address that. So as the trial court concluded on page 83 of the March 4th transcript, it was reasonable to infer that that appellant and Johnson were among the persons who were drinking what was on the hood of the vehicle because it looked like it had been set up for some sort of group activity. So appellant had a white styrofoam cup. If you look at government's exhibit number, I believe it's number, I'm not sure, I think it's 1. It's the still frame. There was a white styrofoam cup next to Johnson. On page 65 through 66 of the trial transcript, officer made clear that he saw appellant walking from where Johnson was. It's the group drinking activity that provides the basis for, and the fact that Officer Rogers saw appellant walking from where Johnson was, that allowed the court to infer that they were associates. Does that address your Honor's question?
Yes, although I noticed you used the word associate in your last comment rather than companion. Companion does seem to suggest a connection, or at least potentially, or connote a suggestion that's a little tighter than they may have been standing together in an indeterminately large group engaged in some sort of general drinking activity.
Well, there was a misstatement in appellant's reply brief about the fact that there were additional people in the area. If your honors look at the body worn camera, there's no one else out there.
No, I'm focused on the trial court's comment about to infer that they were among the persons who were drinking. Which seemed to imply that the trial court thought that there was more equipment out there than maybe two would have been using.
Yeah, and I guess the reason that the reason I said what I said was to just highlight for your honor the fact that there is a reason to think that they are together because and that they are companions because of the fact that they're the two people with, I guess, the instrumentalities of a polka, and there aren't other people out there. So it does give a pretty compelling reason to think that they are the two people who are engaged in those drinks together. But
I guess the question is whether there was a reason to think that they were together in some activity or venture involving a gun. What do you have to say about that? Because that seems to be the common theme in the cases that you rely on.
So I guess I have 2 points to make about that. One is that we are not saying that their association is necessary for us to prevail. We think that because Officer Rogers had reasonable articulable suspicion that appellant was engaged in possession of an open container of alcohol, I'll refer to it as POCA, that he could stop appellant, and that once he had lawfully stopped appellant and was in a lawful position to view the bulge in appellant's waistband, that provided reasonable articulable suspicion for the frisk. There are the additional factors that add additional suspicion, but we don't think that the association, companionship, whatever, however the court would like to look at it, is a necessary factor to our prevailing. In terms of, I guess, the second part of addressing your honor's question, in a number of cases, I guess starting with Lewis versus United States, this court indicated that if we'll call them a primary defendant or an associate or the other defendant, if a primary defendant is found in possession of a gun, then all companions of the arrestee within the immediate vicinity capable of accomplishing a harmful assault on the officer are constitutionally subjected to the cursory pat down, reasonably necessary to give assurance that they are unarmed. So there doesn't have to be any, and that's been followed in cases like Trice and commented on in Williamson, as well as, I'm forgetting the last one, as well as United States versus Bennett.
And to be clear, you said that you don't think the automatic companion rule, if you can call it that, is a necessary, makes a necessary contribution, but I'm gathering from the way you're describing it and what you just said, that you think by itself it was sufficient. In other words, that if all there was here was, the police were, were just canvassing the area for no particular reason. They were on patrol and they saw Mr. Patterson standing or moving away from where he was and saw Mr. Johnson doing what he was doing. And then some officers respond to Mr. Johnson and they find the gun. That would by itself authorize a pat down of Mr. Patterson. If I understand your argument, that's the position you take. Is that right?
We think that it would be a close call, which is why we're not relying on it in isolation. But by the language in Lewis, which is a 1979 case, that would be enough. In the trio of cases that I've also cited, Williamson, Trice, and Bennett, this court has elaborated on Lewis in factually distinguishable scenarios where police are responding to report of a crime in a fast-moving situation, and rather than developing reasonable articulable suspicion that the defendant is engaged in a crime, they are also permitted to stop to frisk a defendant as a witness. That isn't the line of cases that that we think govern this case. This isn't so much a witness case. It's a reasonable articulable suspicion that appellant was engaged in a crime case. So I guess that's why they're not given the focus in our brief. But we do think that it would be enough under Lewis and by the language of Lewis. I'd also like to address appellant's argument that I guess the bulge or the description of the bulge wasn't enough, as I understand the argument. And I would highlight for the court Officer Rogers' testimony on page 19, I believe, of the March 4th trial transcript. When asked about why when asked by the prosecutor why Officer Rogers believed that it was a gun, Officer Rogers responded that it didn't look consistent with the human anatomy, and this is the part that appellant leaves out, it was protruding out of his waistband. And that makes a difference. The fact that it's a waistband and not a pocket makes a difference even under Singleton, which is the case that I understand appellant to be relying on. The reasoning of Singleton is that a generic bulge in a pocket is capable of too many innocent explanations to provide a basis for reasonable articulable suspicion. That was a case where a police officer on the street saw a defendant helping a woman out of a house and saw a bulge in his pocket and furtive gestures toward the pocket. And the court did, as appellant notes, say that was the minimum, that a generic bulge in a pocket had to be accompanied by something more. But this isn't a generic bulge in a pocket. It's a bulge in a waistband protruding out of a waistband. Officer Rogers' full body-worn camera is in evidence. If the court goes to the 3:50 through 4 minutes and 7 second marks or minute marks of Officer Rogers' body-worn camera, we would submit that you can see the significance of the bulge, the prominence of the bulge. You can see that and obviously this is something that Officer Rogers learned afterward, but you can see that it is just about the entire gun is protruding out of his waistband. It's the barrel of the gun that's in his waistband. The entire handle of it is sticking out. And what matters most is that on the question of whether Officer Rogers could see a firearm, could see a bulge, could see a bulge, that the trial court credited his testimony. We think that there was more here than there was in Singleton. Unlike in Singleton, where an officer on the street with no reason to suspect of the defendant there of any crime saw a bulge and thought that was a firearm, here, Officer Rogers was responding to the sound of gunshots in a high crime area at 10:30 at night. Appellant's associate or companion had just been found in possession of a firearm. And that's much more firearm and I guess gunshots related or adjacent information that the officer had here than the officer in Singleton had, certainly. So we think that Singleton is clearly distinguishable on those facts, notwithstanding the fact that, as appellant rightly points out, that there weren't furtive gestures here. That is something that would detract from reasonable articulable suspicion, but there is more than enough based on the additional factors we've highlighted, as well as the fact that it's a bulge protruding from a waistband, not a generic bulge in a pocket, as indicated in Singleton.
Would you
Why
comment?
is the time of, go ahead, Judge Fisher.
Thank you. Would you comment on Ms. Pembroke's assertion that, leaving out the display on the car,
okay,
we don't know that the possession of alcohol by Mr. Patterson occurred on public property? I've watched the body-worn camera videos, and I'm not sure where he is exactly, but it becomes very clear that he has a container of alcohol. But what do we know about whether that was would have been reasonably perceived as a POCA violation?
Sure. Unfortunately, we don't know a ton about it because of the fact that it wasn't raised below an appellant's initial brief or in a reply brief, and therefore it's waived. What we do know about it is that the location of the alcohol next to Johnson was on the trunk or hood. If I look at Government's Exhibit 1, on the trunk of a car. Actually, looking at Government's Exhibit 1, you can see that there are a bunch of cars parked next to each other. There's simply no merit to the idea that this was not a public area. That's Government's Exhibit 1. You see the alcohol in the back of a car, and then pages 65 through 66 of the trial transcript on the March 4th trial transcript is where Officer Rogers says that that's where appellant was walking from. So there's no factual basis for it.
Now, if that rests on the idea that it would be reasonable to kind of play the reel back and infer that Mr. Patterson had been over by the car. If you focus instead on Mr. Patterson's location, it's the extent one can infer it from the body-worn camera footage or reach conclusions about it from the testimony of the officers. That seemed a little less clear to me. There's testimony he's near an apartment building, I know. And right now I'm trying to recall from the body-worn camera footage whether you can tell he's in a grassy area or it's kind of an open area he's standing in, but right now I don't recall whether it was a paved or a grassy or dirt kind of area. I don't know what you know about any of that.
So what I know is what's in the record, which was on, again, page 65 of the March 4th transcript. Officer Rogers said it looked like it appeared that he's walking in the direction of where the other defendant was.
Well, I meant the body-worn camera footage is itself in the record, so I guess you might know what is depicted on it with respect to Mr. Patterson's whereabouts.
I guess I can't really editorialize upon what's in the body-worn camera footage beyond what it shows. Maybe I'm not understanding your Honor's question, just in terms of whether you're asking about the relevance of what's on the body-worn camera to determining, whether this was a parking lot or not.
Yes, I mean the question is, so the issue is, what can you tell or reasonably infer in your view from the body-worn camera footage about where Mr. Patterson was located as it might relate to a claim of the scope of the POCA statute?
I understand. Thank you. Sorry I didn't get it the first time. So at the beginning of the body-worn camera, where you see Officer Rogers approaching appellant, you can see appellant walking from the right side of the screen to the left. On page 65 of the trial transcript, you have that direction is where Johnson was. And then after the stop, where Officer Rogers' body-worn camera is facing that direction, you can see that that's the direction of a parking lot. So from the first few seconds of the body-worn camera, it's kind of difficult to tell where exactly the area is, but even in context of all the evidence that's in the record, this isn't a real issue.
You mentioned a couple of times the time of day. It was 10:30 p.m. There certainly are a number of cases where the time of day is of some relevance, but what's the relevance here? Why does the time of day matter?
It matters as a legal matter. In Singleton, where the court is listing the various circumstances that might amount to reasonable articulable suspicion and the kind of factors that it has held can add to that threshold. One of those factors is time of day. There are a lot of
cases involving whether a defendant would have felt free to leave. Something happened in a dark alley. It was night. So it's a little easier to understand in those cases what the relevance is. I'm just not sure what it is here, although I appreciate your point that time of day is one of a number of factors mentioned in a lot of the case law.
I guess in terms of its significance here, I think it adds to the kind of danger that the officers are getting themselves into and what's known, what's unknown, whether things are clearly visible, whether they are dealing with a potentially dangerous set of circumstances in an area where there is, where it's dark. It goes to officer safety. It also, in certain cases, though not necessarily here, as I think Your Honor is suggesting, could go to whether someone feels free to leave. That isn't really an issue here. This was this was out in the open. It wasn't in an alley or anything like that. So as best I can tell, that's its relevance here. And then just as a legal matter, it does, add something.
Okay. Thank you, Mr. Carroll.
Thank you. If there are no further questions, we'd ask that this court affirm.
All right. Ms. Pembroke, we'll give you a couple minutes if you need them. I think you're on mute.
Sorry. I just wanted to address a couple of things that Mr. Carroll mentioned. First of all, he said that there was nowhere in the record to support the assertion that Mr. Patterson was 20 to 21 feet away from Mr. Johnson. Actually, that's an express finding by the judge below in the March 5th transcript. He says that the defendant was somewhere in excess of 21 feet from the vehicle, referring to the vehicle where Mr. Johnson was. But I think the video speaks for itself. If you look at the video, you can see that there is a considerable distance between my client and Mr. Johnson at the time the police arrived. I would also like to address this issue of the bulge being in Mr. Patterson's waistband. There is no way that you could tell on the video whether the bulge is because he has a pocket inside of his jacket or because it's around his waistband. He's got on 3 layers of clothing. I think that when Officer Rogers testified that it was in his waistband, he was referring to what they discovered after they searched my client and saw that it was in fact in the waistband. But certainly from the
Counsel,
point
can I ask about that? Because I tend to agree with you myself, looking at the body worn camera footage, that I'm not sure I could have, based on that alone, found much detail about any bulge or anything like that. It's kind of dark and it's hard to see. But the trial court had the testimony of the officer, and you're giving a gloss about how the officer's testimony should be read. But if it wasn't explicitly limited in that way, are we in a position to kind of look behind the trial court's finding on that? Did the trial court make an express finding that it was that the gun was protruding from the waistband?
I don't believe that the trial court did. I could be wrong about that, but I don't believe that the trial court did.
But are you suggesting that we should look behind any credibility determinations that the trial judge made based on our own review of the video?
I don't know that I would characterize it as a credibility determination as much as a clearly erroneous finding. As when you look on the video and you can see that the officer couldn't possibly have seen what he was saying he was seeing. It's not so much that he was not credible, but that it was just erroneous to because he may have believed that that's what he saw, but it has to be an objective fact. And if the video doesn't support the objective fact, I think it would be more along the lines of finding that the judge's determination was clearly erroneous, if that makes sense.
It does, although the only thing I would question about that is it's one thing to say that the video doesn't support the testimony, meaning the testimony was one thing, you look at the video, it's if one looks at the video and says, well, I can't really tell one way or another whether the officer would or wouldn't have been able to see what the officer said, then in a case like that, the video footage wouldn't support it, but it wouldn't obviously clearly contradict it. And then one wonders whether we're in a position to look behind the trial court's decision to credit the officer's version. So I don't.
Well, but I think in this
has to support the officer's testimony for the trial court's ruling to be adequately supported by the record. The issue would arise more if the video clearly and kind of unequivocally contradicted the testimony. Then there would be, a stronger issue about whether, and maybe that's what you think the video does, but it's a little weaker to say the video doesn't support.
I do think that the video clearly contradicts the testimony. Yeah, I do think that the video clearly contradicts the testimony of the officer. And the officer also testified that there were 3 layers of clothing on Mr. Patterson. And given those facts, I think that it would be clearly erroneous to conclude assuming the trial judge did that, and I don't know if the trial judge did find that, that Officer Rogers could tell it was something protruding from Mr. Patterson's waistband. I think it would be clearly erroneous to make that finding, and I don't know that the judge did that. I think that, I mean, unless there are other questions, I don't have anything else I want to add at this point.
Well, in that case, we will thank you for your presentation. Thanks also to you, Mr. Carroll, and the case is submitted. And with
Thank you,
that,
Honors.
thank you. The court will stand adjourned. You're on mute, Mr. Brannon.
This court is now adjourned.